So, okay, yes. So thank you very much for coming. So as I say, the last stream will be after, because we have the technical issues. But thanks. Thanks to be there for this conversation about international cooperation digital markets. So, it's important because we have different regulation in different places of the world. And since it's a topic about international cooperation, we have an international panel here. So starting with Hannah from Australia, she sent us the sun from Australia, but not the heat. Perhaps one day it will come where it should be 20 degrees in Brussels. I hope so. And then we have Carolina from the OECD. She came from Paris, but she's Italian. And we have Iwan from the UK CMA that is working on digital markets from the UK. And we have Menno Cox from the European Commission DG Connect International Corporation, International Unit. And you are from which country? The Netherlands. And me, Christophe Corelti, I am an affiliate fellow at Bruegel working on competition and digital issues. And I am from France and on international cooperation, always please the French. So the discussion would be as follow. In part one, we'll introduce the different regulations and whether they converge or diverge. And then we'll do Q&A during 10 minutes where people in the room you'll be able to ask questions. And then we'll go to the second discussion, which is about how to ensure international cooperation, which question from how the debate start, what have been proposed, what are the current proposal, and what is remain to be fixed. So let's start the conversation and open the floor with Anna from this beautiful Australia. And so tell me more about the Australian proposal. It's the last one, but you were the first to propose a complete report on digital platform in 2019, if I remember well.
Well, thanks for having me, and I hope you can hear me okay.
Wait, Anna, we have a technical issue with the sound. It's good because we can see your face is moving, but the sound is not moving.
How about now? Is that better?
This is perfect.
Okay, great. Well, thank you for having me. As will become evident, this is a sort of pivotal moment in Australia as the government is currently looking at the recommendations we recently made in respect of digital platforms. So it's a great time to be talking about these issues. As Christophe said, we first looked at digital platform issues in 2017. We kicked off the digital platform inquiry, looking into the supply of news and journalistic content on digital platforms, which was finalised and published in 2019. Since then, we've produced reports on ad tech, online private messaging, app stores, search services, online retail marketplaces, and our most recent one was on, as foreshadowed, on regulatory reform. While we are still required under the Digital Platform Services Inquiry to keep providing 6 monthly reports, we thought now really was the time to consider whether reform was required to address the competition and consumer harms that we've seen to date in these markets. We were of that view because of the scale and the scope of the harms observed and the persistent market power across a number of markets and systemic anti-competitive conduct that we have observed. We also observed deficiencies in the current law and the enforcement of the current law. That being the duration of enforcement cases, the limited nature and concerns of the cases, and the concerns about whether the remedies would ultimately address the underlying competition concerns, especially in markets prone to tipping. We also saw the speed of regulatory change overseas, including in Europe, the UK, Germany and Japan, in response to those harms that have been observed. So in response to all of that, we decided to make the fifth report on whether or not there was a need for regulatory reform, and if so, what that would look like. So we made 4 recommendations ultimately. We ultimately decided that yes, given the scale of these harms, the fact we're seeing these harms across multiple markets, we're seeing systemic market power issues and anti-competitive conduct. We don't think the current laws are sufficient. And so we made 4 proposals. We made 2 on the consumer side, which I won't go into today. I think the audience is a bit more interested in the competition measures, so I'm very happy to elaborate later if that's of interest. But we made 2 recommendations specifically on the competition side, and that was for a new power to designate digital platforms and make them subject to service-specific codes of conduct. So regarding designation, we suggested that the recommended designation criteria should have regard to the characteristics of digital platforms that give them those critical positions in the Australian economy, as well as the ability and incentive to engage in conduct harmful to competition. We also recommended that the designation criteria could be based on quantitative criteria or qualitative or a mixture of the two. And then regarding the codes of conduct, have you still got me there? No?
I can hear you, Anna.
You can hear me? I think we've lost the others.
You okay. We have a problem. So what you were saying about code of conduct. I'm sorry for this issue.
Yep, you've got me back?
Yeah. You are online. You are on Earth. No worries.
Okay, back on Earth. On the wrong side, it seems, but I'm still here. So the codes of conduct would be developed with targeted and specific obligations to address the anti-competitive conduct, barriers to entry, and unfair treatment of business users that were observed in the specific markets. Those targeted obligations would be based on high-level principles that would be set out in legislation. For example, the promotion of competition on the merits, informed and effective consumer choice, and transparency for digital platform users. And the types of issues addressed in the codes are discussed in quite a bit of detail in Chapter 6 of the report, but they include things that will be very familiar, I'm sure, to this audience, things like self-preferencing, tying, exclusive pre-installation and defaults, the frustration of consumer switching, denying interoperability, data advantages, a lack of transparency, unfair dealing with business users, and exclusive agreements and price parity clauses. So quite a bucket list there. We went down that route with the hope that it would allow flexibility, which we think is important as these services can change quickly and new conduct can also arise. And we think in Australia in particular, codes like this would be easier to amend than primary legislation. We also thought having service-specific codes of conduct means that the obligations can be targeted in relation to the harms observed and tailored to those services in particular. So just to wrap up, I know that's a very quick overview and happy to take questions later, but where we're at now is we provided these recommendations to the Treasurer in late September, and the report was released publicly in November. In late December, the Treasury opened a public consultation on the recommendations, and submissions are currently open, with those closing on the 15th of February. Whether or not these recommendations are ultimately adopted is a matter for the government, and also the detailed design would still have to be undertaken by the government. But we do think the ACCC thinks that these reforms are necessary and will bring significant benefits to Australian consumers and businesses. So thank you.
Thank you, Anna, and sorry for the interruption. And it's interesting. We'll come back after for the inspiration why you decided the code of conduct in Australia, because then I will ask to Iwan to present the UK proposal, which is a little bit similar to what is the Australian proposal at the end of the day, but perhaps he will speak better than me about the UK proposal. So Iwan, if you are online.
Yes, can you hear me?
Yep.
Yes, excellent. Good afternoon, everyone, and thank you, Christoph. You're very, very right. I could make my presentation very short by just saying ditto. Our proposals are very similar to the Australian proposals, and the genesis of them is very similar in terms of the problems that we have identified in digital markets and the deficiencies we've identified in the current legal framework for addressing those problems. Ours began in 2019 with what we call the Furman Review that reported and made similar recommendations to the ACCC. We then progressed through more detailed design and a consultation period between the government and the public. And in the autumn, our Chancellor announced that a digital market, consumer and competition bill would be introduced into Parliament at some point in the third session of our Parliament, which means some point before this summer. There's very similar, as I've said, structure to the law. There'll be four main elements of it that are relevant to digital markets as we're talking about today. The first is, as per the Australian recommendation, the designation process. So we will be establishing strategic market status firms, and they will be firms that have substantial and entrenched market power in a digital activity, which gives them a position of strategic significance in the UK in relation to that digital activity. And there'll be a threshold test for revenue to ensure that only the largest firms will be captured. Digital activity will be defined broadly in the legislation, but it'll be up to the CMA to pick particular activities subsequent to the legislation that we want to designate firms for. That will be the entryway into the regime for the SMS firms, who will then face a range of obligations. Those will be conduct requirements, which will address the symptoms, so it'll be behavioural changes with respect to how the company is using its market power. It will be pro-competitive interventions, which is where we need to go further to address the underlying root causes of market power. And there will be merger reporting obligations and new information gathering powers for the CMA vis-a-vis those companies, particularly with respect to algorithms. The conduct requirements are very similar to the code that Anna was talking about. And what we're going to be doing is setting out objectives, so principles of the code in legislation. They will be fair dealing, open choices, and trust and transparency. So a similar range of things that we'll be able to take action with respect to, as Anna was mentioning. So fair dealing will be that users or potential users are treated fairly by the SMS firm, are able to engage on reasonable terms. Open choices will be about requirements that users are able to choose freely between the SMS firm's offerings and those of their competitors. And trust and transparency will be requirements to ensure that users are able to understand and make informed decisions about the SMS's offerings. Pro-competitive interventions, where we have to go further, will be similar to the powers that we have under our existing Enterprise Act, where we can specify behavioural or indeed structural remedies through orders. Ultimately, we will have in law the power to fine companies up to 10% of worldwide turnover where they are in breach of their obligations. But something that we have been very firm on throughout is that we and the government want this to be a participative approach. We rather want to avoid formal enforcement mechanisms and proceed through collaborative rather than pugilistic relationship with the firms. The details exactly of how we're going to do that aren't specified in the legislation, but it's something that we'll be setting out more on what this means in due course. And I should just add to wrap up that this builds on quite a bit of work that we've been doing in digital markets under our existing tools. So we have currently, I believe, 10 ongoing cases under our antitrust, consumer, merger and markets laws. We have undertaken market studies into digital advertising and mobile ecosystems, and we currently have a market investigation underway with respect to the provision of mobile browsers and cloud gaming restrictions in mobile ecosystems. So this is building on quite a fair bit of knowledge and structure in the CMA already that exists to deal with digital markets. So I'll stop there, but happy to take any questions.
Oh, it's interesting for two things. The first point is that you are doing code of conduct in Australia and in the UK, which is different from a model that I will present in. Menno will present in 1 minute. So be ready, Menno. And the second point, which is interesting, is that in the UK, you already start by basically doing capacity building, which is a lot of staffing. I was at a panel last week, and one of your colleagues told me that they are recruiting 100% just for this year's at the CMA Digital Market Unit, which is a lot compared to the commission that has only 32 people right now for the DMA. But Menno, the floor is yours. Code of conduct. In Europe, we have more regulations. So I think it's necessary for you to present the DMA in deep, because everyone in the room and online know what is a DMA, but more about what do you think that this approach is different from the code of conduct?
Yeah, thank you so much for having me. I think what is, as we were all showing off our pedigree in regulating online platforms, I can't help myself. I mentioned that the EU started this all in 2015, and then with the publication in 2016 of the platform communication that already outlined a lot of these problems that we saw. But rather than standing on that as a major achievement, I would say it shows the urgency of acting now in digital markets, because already then it was noted that there is structural problems where economic power concentrates around gatekeeper platforms, and we need to act fast to safeguard innovation. So I think today is very timely, and I would say every event during this year as crunch time approaches is very timely and important. Today is also the State of the Union speech of President Biden, and it is widely expected that platform regulation will be a major feature of that. But be that as it may, we do not have the enforcement of platform regulation in place anywhere in the world yet. And I think it is extremely urgent that this starts, and that the first part of international cooperation, rather than a concern about consistency, is actually changing the status quo. And that then brings me to the EU approach, which indeed is slightly different. I think we share the problem statement, if I can call it that, around the globe. There have been reports by most, if not all, regulators in the major economies, and indeed the G7 economies that have mapped this. And action is being undertaken. But now in the EU with the DMA, we have a regulation in place that, in my view, is truly ex-ante regulation. And I think it's important that we pause for a moment on what ex-ante actually means. And I'll explain how I think the DMA qualifies as such, and why we need such ex-ante regulation, and for it to be enforced now and not in some time from now. So what ex-ante means, if you apply to the DMA, is rules that apply to all services that are specifically identified, rules that are very clear so that all participants understand them, gatekeepers included, but also rules that apply in all cases. This is crucial because the difference between competition law and ex-ante regulation hovers around that idea of rules applying in all cases, so that participants not only understand them, but also know they will be able to rely on them. So perhaps rather than rules, they are new framework conditions for innovation and contestability in digital markets. And indeed, the Digital Markets Act very importantly lists exhaustively what these new framework conditions are, but it also clarifies that while certain security and privacy safeguards can be put into place, they are never a reason, privacy and security concerns, not to comply with these new framework conditions. Otherwise, they wouldn't be framework conditions. And I think that is a bit of a philosophical discussion we perhaps should be having around what will be able to make that structural change that we all need. Once we achieve that, I think there will be mutual benefits from platform regulation in different jurisdictions around the world, because what we will be achieving in Europe is regulation that applies to all gatekeeper services, and on the basis of which businesses, small and large, gatekeepers included, can start to innovate, being reassured that these rules will apply in all cases, and determine how they can build their business and innovate. And that innovation benefits other jurisdictions as well, similar to us benefiting from other regulations, jurisdictions successfully regulating gatekeeper platforms. So that's just a call for urgency, that we need to focus now on implementing. And I'm happy that we are now able, with the rules with the Digital Markets Act on the books, to start doing that. And you know that per the 2nd of May, the Digital Markets Act will apply, and then by September we will see by the latest we will see the first designations, and then the list of obligations will apply in March 2024. So we are moving, and before that date, importantly, gatekeepers will be testing compliance or implementing solutions, and that needs to be done very widely and involving all stakeholders. And some first examples have been done. You may have seen a workshop that was organized on self-referencing, and others are to follow on specific topics like interoperability and software application stores in Europe. And that is also a piece of regulatory expertise that is shared with the world, because that's inherently public. And I think we need a lot of that, so that we can all test solutions and get ready for implementation, and also make sure the solutions actually work to improve the situation for final users as well as for business users that need them. But I think that's the key, that the DMA is exhaustive in setting out the rules. It tries to be very precise. Where further precision is provided, perhaps in more technical implementing or delegated regulation, it's always tested with the public, and compliance solutions are broadly tested with all stakeholders to make sure they actually work. So very much focus on implementation and enforcement. And I think the international cooperation naturally is built into this process. So just a final word on that. I head up a section dealing with the global aspects of the Digital Markets Act and the Digital Services Act, but I also specifically enforce those two acts, as do other team members, because that's what makes this a unique situation. We will tackle the same global problem, and all of us will benefit from good regulation of these gatekeeper services. So we need to be able to share that expertise firsthand and get the enforcement right, and that you do that also through global cooperation. And we do that already today with our global partners in the G7 and through the Trade Technology Council with the United States, our digital partnerships with Korea, Japan, and others that are upcoming. And so we have a very close eye on the global aspects, but a focus on enforcement right now. Thank you.
So I guess you will not go in Australia this summer to see Anna and speak around the coffee, because you will have no time until September.
It'll be a busy summer, but we also have a clear focus, as I mentioned, on the international cooperation that's built in, and we're in close contact with Anna and others, all other partners around the world.
You pointed upon about, I like what you say about it, just to pressure, basically, we need urgency to act right now, and which international cooperation, you pressure the big tech basically to be more in line with the rule. And you have also the model of participative approach, such as in the UK. But so we mentioned the UK, Australia, and Europe, but there are also the model in the world about digital competition. And here we have Carolina from the OECD to touch upon some of the other models, not all, but at least one from the G7 countries. So the floor is yours, Carolina.
Thank you, Christoph. So at the OECD, actually under the G7 German presidency, we compiled a broad inventory of reforms going towards the conversation on international cooperation. This was an important step that the G7 asked us to take part of in order to be able to assess convergence and divergence between the different models. I know we'll touch upon this topic later, but I think for the conversation it's important to at least introduce two other proposals from Germany and from the US. As you may know, the German reform has already been implemented. The difference with the German model is that as opposed to the other systems, the reform has not been introduced as a separate act, but was introduced as an amendment to the Competition Act under Section 19A. So it's a bit different from the other models. In the US, all the proposals are still under discussion. There are a total of, I think, 5 bipartisan bills under discussion, but 2 of them are generally considered to be the ones that will possibly, in some version, be implemented. One is the Open Up Markets Act, and the other one is the American Innovation and Choice Act. Both of these models, the German and the US one, with many differences, but at the core, they follow in a way the rule-based system of the DMA, in the sense that the regulation introduces a specific list of do's and don'ts for gatekeepers. In the case of US, they would be called cover platforms, but the subject is always platforms with a specific type of market power without necessarily requiring a finding of dominance. This list of do's and don'ts is in some cases a little bit more flexible than in the DMA. For example, in the German case, the authority can, in a way, pick and choose from the list depending on the business model of the specific company at stake. But overall, I would see this big differentiation between principle-based models that we see with the UK one and the Australian one, and rule-based models that we see with the DMA, Germany, and possibly in the future, the US. I would also briefly maybe mention Japan for the conversation. Japan is a bit of a different case. They have an act that focuses on transparency and fairness. So the scope is much more narrow than the other reforms that we are talking about. And it's a dual system in the sense that the designated platforms, because even in their system they have a designation process, they will have to follow a code of conduct type of self-regulation, but they will also have to follow specific rules, for instance, in terms of having to disclose the terms and conditions for the business users of the platforms and notify any changes. I would define it as a dual system, although it's not exactly comparable to the other reforms, given its narrow scope. And the other difference is that in the case of Japan, we have METIS, the Ministry of Economics, that will be the main enforcer. So I would not consider Japan as part of this big effort to regulate ex ante specific types of digital platforms, but I think it's still important to see how in other parts of the world countries are trying to address these problems, not to be too Western-centric. Although the work that we've done so far at the OECD does focus on G7 countries, we are working to expanding in the future. We're waiting to see what's going to happen with Korea, where they have implemented a reform that is very much specific on app stores, but there is under discussion a broader reform that could look like a European-style ex-ante regulation. I think what is interesting now to say is maybe more how these reforms converge or diverge, but I will give the floor back to you.
It's worth talking. So you mentioned Germany, the US, and Japan, which are in Germany is already implemented, and in the US, we don't know the outcome. Like you said, President Biden will perhaps say some things about, but apparently in the US is difficult to pass antitrust bill, and to the best of my knowledge, the last time that I checked the number of bill about digital competition, there were more than 15 bill before Congress. So it was a lot, but only 2 may be relevant with a chance to pass. And of course, you have other countries. You have India, but also Canada that are planning to have also kind of digital competition regulations. But let's now speak about the second part of this discussion, which is about convergence and divergence. So it was a presentation, but now let's go more in deep. Is more together discussion between all the panelists about what those will converge and then diverge, to see what's the need for international cooperation. So let's start with convergence, and we want to speak first. So where do you see conversion between all this model, which you're going too much into the detail of the rule, of course. Yeah.
Perhaps I can start.
Yeah, go ahead.
Convergence, I think, from all of these presentations exists around the problem, the fact that innovation is structurally at risk here, which is something that some years ago we still had to arrive at this common conclusion that we really face a risk that even our existing competition laws cannot safeguard or preempt. We really need to make a structural change. I think there's also convergence around the fact that we need service-specific designation, which reflects the gatekeeper position of online platforms, which is also an entirely new concept. We're no longer defining markets and identifying who are relevant within those markets. It's really the differentiation that platforms specialize in, and which allows them to then capture an entire intermediation segment that requires that designation, so that you know exactly which are those gatekeepers that are crucial for doing business online, and the fact that you then also need to identify them as such. And that's maybe somewhat similar to the concept of systemic banks, where you also identify them and then know who your regulated entities are. There's convergence about the fact that certain practices, when engaged in by these firms, are in most, if not all cases, problematic, and that we need to varying degrees of specificity rules to change them. And I then think it comes to the implementation specifics where the more fundamental differences lie, but I see a lot of convergence.
Maybe another interesting aspect for the designation of platforms is that none of the proposals only use quantitative criteria for the designation. I think apart from Germany, that uses mainly qualitative criteria, all other proposals use both quantitative and qualitative. I'm not sure if it's a way to, maybe correct past mistakes, that if we can call them mistakes, learning from merger control and the issue with killer acquisitions often not being notified. So an over-reliance on quantitative thresholds. So I see this kind of development that is shared by all the proposals, quite a relevant one, because it kind of hides, I guess, a broader consideration of what really the objective is and what these regulations are trying to achieve with the designation process. And although the criteria are in part different from one regulation to the other, the main objective to tackle a specific type of market power that is not so strictly linked to dominant position in the more traditional sense of antitrust, I think it's a very important convergence, because at least we know that we're moving in the same direction and that we want to be flexible in how we define that market power. Like in the US, it's a bit more towards some sort of intermediation power or gatekeeping power, but the idea is really to go at the core of market power and the causes of market power rather than a more formalistic approach.
So, Iwan, you have the hand check. By the way, your case study is really beautiful. I want to go there.
So, sorry, can you say that again, Christophe?
I was saying you have the hand left, and I want to visit your case studies. Look like very beautiful.
Ah, that is Edinburgh Castle.
Oh.
I'm actually in Glasgow today, but my office is normally in Edinburgh. Listen, I just wanted to add to what Mel and Carolina have said. I think really this is the main part of the conversation, that there are more things that unite us than divide us. I think we have very, very similar regimes, even if the way that we're addressing some of these issues may differ slightly. Ultimately, the problematique is the same, and the ultimate remedies, the behavioural changes that we want to see, are the same. I think what is similar features to all of the regimes that Mel picked on in particular earlier was the ex-ante nature of these regulations. We're all recognizing that because of the scale, scope, and speed of the firms in these markets, we need to be able to engage in a much more reactive, participative way and avoid the protracted court battles of the past that mean we haven't been able to remedy problems before it's too late, really. And I think the other thing that's similar that's worth drawing on is that there really is a distinction here between the little guys and the big guys. What we are requiring of the big guys is behavioral constraints, behavioral changes that would be overly burdensome to the little guys. So there is a distinction between the size of the people that we're intervening on. So I think those are the two features that I think are really striking to me as being common. But really, even if we might get in the later part of the conversation about principles versus rules and the nature of the code approach that Australia and the UK are taking, I don't know that it's as different as with respect to the DMA as perhaps we might be led to think.
Anna, do you want to add something about
Yeah, I should have gone first because everyone's made very excellent points already, and I'm going to be very dull and say I much agree with everyone. I too see that really we're talking a lot more convergence than divergence. I think we've really come to understand the problem in the same way in these various jurisdictions, both in terms of, the economic characteristics of these businesses that are leading to these problems, the inadequacy of current laws to deal with those, the types of conduct that we're seeing in these markets that are problematic and are harmful, and ultimately what we classify as the ultimate harms to consumers, as Menno said, that sort of loss of innovation and productivity and those other things that we're seeing. So I think there's really a lot more in common than there isn't. I would also say that I think when it comes time to implement, in some ways we know a bit more what's going to happen in the DMA in Europe than we do in the UK and other jurisdictions that may go down a codes path, because those rules will be within those codes. And they may, in fact, look very much like what we see in the DMA, but maybe more specified to the particular circumstances in a particular market. And some of that may just be also a reflection of the different legal systems behind those jurisdictions and other consideration that need to be taken into account. But I think really the problem specification is very similar. The problems with existing laws very similar, and really where we're wanting to head very similar. And we could, in fact, have something where, even though the laws might look a little bit different, or the form in which they take, a remedy in one jurisdiction ideally would be a remedy in another, and that's I think where we want to head, even if things look a bit different, that a remedy in one, if it's acceptable under one piece of legislation, hopefully if it's addressing the same issues, is acceptable elsewhere as well.
So we agree that most will converge first about the designation, which is true, is new, because previously in competition law you have to define a market. It's a long time process, and some jurisdiction may have different interpretation of what is a relevant market. Whereas the designation is pretty clear; it targets all the same firms, irrespective of whether the name is different. In Germany, we have even a long name, which is a firm with significant paramount across market, that is German. So it's not much that is long. So now let's move on to divergence. So it's nice to be speak about the fun part, but there is the unhappy part about some divergence. The way I see the diversion, but the panelists will perhaps say more, is first of all divergence in some rules. So, for example, under the DMA, you have interoperability requirement between messaging services, which is not the case in some other regulation. And the second one is, for me, the way I see the risk is the divergence in interpretation of the rules. So even so you have similar rules, the way you interpret the rule may differ between jurisdictions. So what do you have any thought of that?
Could I again start? I'm very sorry.
Go.
And apologies to the other panelists. One piece of divergence which doesn't lie in the rules, again, is the state of where they're at. And I think that's important. That goes back to this point of urgency that I made earlier. The DMA is adopted and is being implemented. Other rules at this stage around the world are still at the conceptual stage. And even though we see many proposals in the United States, for example, as were mentioned, it is unclear whether and when they will see the light of day. So that's the first point of divergence. And I don't mean that in an adversarial way, but I do think we stand to gain also from staying very closely in touch as global regulators, whoever takes the first step, but try to actually make that enforcement a success, because as I mentioned, that is an urgency. Then the other divergence lies more in the specific rules. And I would mention perhaps Article 5 of the Digital Markets Act, which is the article that applies in all cases, as do Articles 6 and 7, but where in principle also no further specification is possible through a dialogue, or whatever you would like to call that, with gatekeepers. And that reflects the fact that this was really meant to be clear-cut rules that apply in all cases, that will already be enforceable also on a private law basis, directly from the regulation that applies in all 27 EU member states. That is not to say Articles 6 and 7 do not apply in all cases as well. They do, and they can also be directly enforced, but their gatekeepers can ask for assistance in designing and testing their compliance measures. But I think that is a crucial point of divergence as well. There is no way to argue that a certain provision shouldn't apply in a specific case for a gatekeeper. So they always need to be applied, and that gives that legal certainty to stakeholders.
So you mean no dialogue for Article 5?
Yes.
Okay. I mean, if you read the provision, this is true that are clear and so on, but I'm pretty sure that they will find a way still to speak with the Commission on misunderstanding about what consent mean or how to implement the consent, especially so, and Hannah loved this topic about the issue of dark pattern. How do you frame the consent framework? And I'm pretty sure this will be a topic of discussion between the gatekeeper and the Commission about or do you ask consent to users? Can you say accept all or decline all, or can you say ask application to track or not to track? So the way you frame will have an impact at the end of the day. But maybe Hannah first on this issue of divergence.
Sorry, I couldn't find my mouse. Yeah. I think it's an interesting one, and I think obviously when we were looking at what sort of regime we thought would work in Australia, there is that tension between trying to build in some flexibility to account for various scenarios, and also conduct that may in some circumstances, while it might on the face seem anti-competitive in some, in others it's benign or pro-competitive. So I guess that was the flexibility that we were trying to build in and going down a codes of conduct route. and regards the certainty, I mean, there's less certainty, I guess, before the code is made, because you'll just have got those guiding principles in the legislation, perhaps. But there's going to be a lot of certainty ultimately once the code of conduct is written. So, yeah, look, I think it is a difference what form those sort of defences take in Australia, whether there are any, whether there's carve-outs for privacy, security, anything like that, how much dialogue the regulator engages in and those sorts of things. I guess they still need to be tested. And I can see as well, like, the appeal of having some provisions that theoretically are there as prohibitions that need to be complied with in all circumstances. But I think you still get into problems like we do indeed with, you know, our competition law about what is anti-competitive XYZ, and ultimately, you know, that might be clearer in some jurisdictions than in others, and the courts may interpret things differently as well. So there are maybe good reasons for diversions as well, reflecting those considerations, I'd say.
Do you want to add something?
Like other presenters before, I agree with what's being said. I think, as Anna has said, there is logic that is stemming from the legal structure in each of the different jurisdictions that has driven the choice that we've made, in particular on principles versus rules on the face of the statute. And I should emphasize that it really is a choice. There are merits to both of these options, and I don't think anyone is particularly wrong. Why we chose to go down the route that we went down is similar to Anna, as with respect to the certainty after the code has been drafted with firm-specific detailed code and accompanying guidance. One of the big reasons is future-proofing. So it's very difficult for all of us to change laws, but it's particularly difficult in the UK. So we don't want to have to use primary legislation to amend any of the rules further on down the line as technology develops. We want to be able to respond as a regulator without going down the legislative route. And the other reason is avoiding courts. We really want to have this ex-ante participative regime, rather than having the firms battling out how the legislation should be interpreted in court from the rules that are there. We want to design that in the code requirements through participative regulation. And we have a different, government proposing a different appeals standard for this regime. So the companies will be only able to challenge on a judicial review, which means the way in which the regulator has gone about making its decision, rather than a merits review, which means reviewing the underlying logic of the decision. And we think that's easier if we do it through the code route, rather than having everything written on the face of the bill. But again, it really is a choice, and both approaches have merits.
Thank you. Carolina, do you see any diversions from the
maybe going back to one of the first points that was made, I think for divergence, it is a bit less clear in the sense that we see how the same conducts, for example, are addressed, but we see how the differences are at the margin, and that margin will become clear only with implementation. So to make an example, there is a same awareness around the fact that gatekeepers use an accumulation and combination of data is a very important element of market power. So it's something that should be addressed. And all of these regulations do address these data-related aspects, but in really marginally different ways. For example, for interoperability, certain regulations have a positive obligation to allow for interoperability, while others have a negative prohibition not to impede interoperability. So on paper, this looks like they're really moving in the same direction, but then with implementation, we'll see how these different wording will actually have an effect in practice. And this is the same, for example, also for provisions around self-preferencing. The fact that the DMA focuses more on self-preferencing in relation to ranking, while the US proposal, for example, is broader. So it covers any type of favoring of your own, if you're a gatekeeper, services. in comparison to your rivals. We will have to see in practice when the same gatekeeper is covered by both regulation, what that will imply. So I think while convergence, it's quite clear because it's more on the approach and in a way the philosophy of the regulation. Divergences will really be at the margin and we will see them then in practice. And so far, given this different timeline of the different regulation, it's very difficult to see what will happen. And then, I mean, the point of flexibility, I think that although it may appear as a divergence in a way, it also shows kind of a similar approach in the sense that I completely agree that the DMA with respect to more principle-based systems is, in a way, potentially ensures more legal certainty because you have a list of provisions and that's it, and they apply in all cases. But I think if you look also the German, the US proposals that are more similar to this rule-based European system, they all find ways to introduce some degrees of flexibility. So in the DMA, we have the, let's say, possible negotiation in a way with the Commission on Article 6 and 7. In Germany, we have an objective justification that is allowed, and at the same time, the authority can pick and choose between the list of provisions depending on the business model. In the US, you have an affirmative defense possibility for companies. So it's clearly different, and it's still in a way less flexible than a UK or Australian system. But there is, like, we can see how they're all trying to insert an element of flexibility. Exactly because everyone is aware that its digital markets are very complex, they evolve quite quickly. So even under rule-based systems, we do need that level of flexibility.
And I from an economic standpoint, the way I like to have this divergence of regulation is that you have the famous learning effect. So we'll be able to learn from Australia, we'll be able to learn from the UK or from Europe, but also from other jurisdictions. And then find not the best model, but at least the optimal solution to common issue, which is, in my view, the right way to do. Because if you have a monopoly with one regulation, in that case, you don't learn and you don't innovate. It's also innovation from competition also apply for regulation. But now we are perfectly on time for Q&A for this first session, and it's not online, so you're lucky you. We have more time for you, the audiences that is in person. Do you have any questions for these first sections? Don't be shy. No one? Not even on specific rules or specific aspect. I know that some of you are here because, you know, you want to tackle the digital competition for your business, and that is, of course, why we have a regulation. Yeah, one question to the, if you can say your name and your affiliation, it would be perfect.
Hi, thank you very much for the talk. My name is Friedrich Lucke. I'm from the Joint Research Center of the Commission. I have a question that probably goes mostly to Mr. Macmillan. You talked a bit about the participatory approach towards policing the companies with respect to competition. And I was just wondering what sort of experiences led you to this approach, and in context of digital markets, whether you think that this approach can prevent sort of the companies from influencing the regulation too much and sort of trying to avoid the policing because the approach is very participatory and not so confrontational.
Thank you. That is, sorry, should I go ahead, Christoph?
No, go ahead. Just I need to fix something on Slido. This is why Mike asked my colleague to come. But go ahead.
Thank you. It's an excellent question. We obviously have other regimes that are ex ante that have close relationships with large firms. So our closest analog would be Ofcom, or communications regulator, and their relationship with the telephone operating companies. So we have experience there that we can draw on. We have other similar approaches of ex ante regulation in banking and groceries. So we'll be drawing on that. I think regulatory capture is obviously a risk that we need to be cognizant of, and that's why we said that we won't only be consulting with the SMS, or strategic market status firms, closely analogous to the gatekeepers in the DMA. We'll be consulting with other industry players, so challenger tech companies, consumer bodies, academics, etc. So we'll be triangulating a range of voices to ensure we're not only hearing from just one company. But I'd point to what I think is a really positive example of this kind of engagement already under our existing framework. So we have a Competition Act 98, or antitrust legislation case with Google with respect to their privacy sandbox, which is changes that they have made to third-party cookies, which had the risk of cutting out other data users from access to data that Google itself would have. And Google's made commitments with us to work with us to ensure that that doesn't happen, and that the new approach to cookies does not create a barrier to foreclose rivals. And that's something that we are working in a participative way with Google, and so I'll perhaps mention the second part of the talk later on, is something that we're kind of leading the way for the world, because Google is committing to do this on a global basis. So I think we already have some experience that where interests align, at least, the big tech firms are willing to engage in a participative way. Of course, that might not happen further on down the line where interests just don't align, but we think there's quite a lot of experience in the UK in dealing with that we can draw on.
So exactly, we have the same participant approach in Europe, which commitment. The Amazon case is one example. And for the record, I'm writing a policy contribution on how to do a participative approach for digital competition regulation that will come out soon. So stay tuned. Any other question in the room?
Hi, I am Conrad Ferenci from the Center on Regulation in Europe, and I have a question about divergence, and you mentioned a lot of interesting insights about divergence and potential divergence, because of course the DMA is much more advanced than other pieces of legislation. But I'm wondering whether you see any potential problems coming or arising from divergence, and whether you think that there can be any issues that have to be foreseen with managing coexistence of similar but slightly different regulations worldwide.
Maybe I can take that question. Very important. I think we'll also address that as part of our discussion on the need for international cooperation and coordination. So that is something you always need to guard for, of course, that you, in a way, prevent through your enforcement actions the possibility for a global remedy. It was just mentioned that also in competition law, sometimes there's the possibility for remedies to be applied on a voluntary basis around the world to the benefit of all. So it's important to prevent that we stand in the way of such solutions. But I personally am not so worried about inconsistency at this stage, but rather, as I mentioned, about the fact that the status quo may not be changed in time enough. And I think we all stand to benefit from acting. And as we cover the same and sometimes even a few additional services, I do not see that we now, by acting, create huge inconsistencies in the implementation that would create problems. And that's partly also because the rules are a minimum set of obligations required for these markets to function in the first place. And the law is also very much focused, the DMA in this case, on preventing circumvention, for instance. So the whole dark patterns point that you mentioned before is explicitly referenced in the article on anti-circumvention. So again, it's very much focused on the risk that these rules are not complied with, rather than that they are complied with, but that the gatekeepers do regulatory arbitrage or so and try to hold one solution against the other and say we cannot comply sufficiently with your regime. It's really a matter now of changing these fundamentals and having these minimum obligations complied with. Then it's important that there is flexibility, rather, to try to make sure that there's no anti-circumvention or that new practices are also adequately captured. And I think it was mentioned before, all of these acts have that element of flexibility built in. And the Digital Markets Act does that through allowing updating of the obligations through delegated acts, so that you don't have to rewrite the whole principle regulation, but can actually attack the same behavior through updating the existing obligations. And I think that is a crucial element. Of course, as I mentioned, international coordination is built in from the get-go, and that's why we focus also within the enforcement teams in the EU on the global aspects. So always being mindful of those and speaking to all of our global partners in a whole host of fora. And I can tell you there are a lot.
And you have a difficult task if I'm taking, for example, the Apple Store case in South Korea, in the Netherlands where you come from. We have this issue in Europe, but the way that Apple will implement its compliance measure will be perhaps different in South Korea and the Netherlands than in Europe. So it will be interesting to see. Unless there is another question in the room, I will another one.
Thanks. Seems like all the questions are coming from this corner of the room. Max von Thun from the Open Markets Institute. So my question is a bit less about legislation, but more about the type of remedies that enforcers consider in digital markets and how they sort of work together on deciding those. I'm sure everyone in the room is aware of the big DOJ lawsuit that we saw a couple of weeks ago, seeking to break up Google's position in the ad tech supply chain, very much focusing on structural remedies. Obviously, behavioral remedies have been more in vogue for a long time. Maybe there's a slight shift now, but do you think the kind of what the DOJ is doing will influence, for example, the Commission, the CMA, who are doing their own investigations into very similar issues that the DOJ was looking at? Do you think there will be an influence in that sense in terms of looking at structural remedies?
Very quick response. I think here too, we luckily build on a global evidence base of certain concerns. On the one hand, so there is a good understanding of what the issues are and what remedies could be. Then on the other hand, we of course need to see what will happen in practice. And then when it does happen, make sure it's coordinated. But that is a reassuring fact. And it's actually good to hear that action is undertaken. Maybe it does raise another point, which is, are we talking about the enforcement of competition law in digital here, or about this ex ante regulation of digital platforms or digital services, which I think we see as two different things in the EU, where really the regulation also goes hand in hand with what we do on content regulation, for instance. The Digital Services Act is really the counterpart of the Digital Markets Act. And we see that this should happen ex ante and comes as a complement to competition law, which should still be enforced also in digital. But I think perhaps others would also like to speak to that.
Anna, you want to add something? You had this up.
Yeah, I was just going to say, we're a small jurisdiction in Australia, so obviously anything happening in larger jurisdictions is of relevance to us in considering these issues, and we'd be silly not to think of those things. I think as well, as a small jurisdiction, it's about trying to leverage, I guess, things that are happening overseas sometimes rather than trying to be the main proponent of some of those things. So it's obviously very important for us to be engaged with our overseas counterparts and understanding them, because I think contrary to something like the GDPR, where Europe by going first sort of set the worldwide approach of these companies, we're not seeing the same happening necessarily in digital platforms. They're really, when there's a case against them under traditional competition law, they're putting that remedy in place generally in that jurisdiction and not rolling it out elsewhere. And I guess that goes to that kind of call to action that Menno made earlier, that if we don't sort of make these changes, I don't think we're going to see these things rolled out necessarily globally, even though you've got a great example with the privacy sandbox. So I think that's why it's really important for jurisdictions of all sizes to sort of be engaged in this dialogue and part of it, because I don't think we can expect these digital platforms to necessarily roll out remedies in one jurisdiction elsewhere.
So it's perfect, Jen, for the next part of the discussion is how to ensure international cooperation. You mentioned a question about remedies and the question about the risk of divergence. And then the first question is how to best ensure international cooperation. So here I will just introduce the context. So at least for the G7 part, so a little bit of story. There were a famous meeting in France, in Chantilly in 2018, and under the G7 French presidency, and the digital minister decided basically to say, well, let's speak together and we try to ensure international cooperation. It was a start of a beautiful story. Then it was the G7 presidency under the intestate, but nothing's happened very concrete because it was during COVID. And then it was you won under the UK G7 presidency, where something's big come because you say that you share, the G7 countries say they will share the objective about achieving a digital competition regulation. And of course, they publish the first compendium in digital market, which is very useful because you can see what each country is doing. And then last year's the G7 presidency under Germany, where they are trying to make more concrete proposal on how to achieve international cooperation. So we have this comparison from the OECD of country, this analytical framework, and they are starting to think about concrete measure. Okay, so this is the play, but perhaps no less to known about what have been proposed so far. And the second discussion is what are the current proposal and then what remain to be fixed. So perhaps Anna, in a few words, what has been Carolina, in a few words, what has been done so far?
Yeah, so I will start by saying that the OECD has been working on international cooperation for a few decades now. There is a key recommendation from 2014 for enforcement cooperation. It's an OECD recommendation, so it's not binding. But that was a bit the starting point for a broader discussion on how countries could enhance their cooperation and in which direction to move. And the last committee that we had in November, there were proposals to make some of the recommendations, especially in relation to investigative assistance and informational getaways, binding. And this is a clear sign that in order to progress from the international cooperation perspective, first of all, there is an issue related to the willingness of countries to to do that, and even at the cost of requiring legislative change at the national level, which is not, of course, granted. The main direction that I see coming out of the different work that the OECD has been doing, including the report from 2021 with the ICN and the survey that was done in that period, is the need for enhanced cooperation. And I think that could work quite well as an objective for enforcement cooperation. But if we talk about ex-ante regulations, I think we need to kind of step back a little bit and realize that we are kind of past the step of talking about enforcement cooperation only, because when we talk about these regulations for digital platforms, there is an element of cooperation on competition policy, which is more difficult and broader than enforcement cooperation. And there is an element of cooperation for legal implementation. And these other two layers, I think, should really be the focus of any conversation around international cooperation. I think what we see as the next step is a focus more towards coordination mechanism, exactly because coordination mechanism would really help also with the legal implementation and with competition policy considerations from the perspective of cooperation. Coordination mechanism would still require enforcement cooperation. I would still require, if possible, enhanced cooperation. And by enhanced cooperation, I mean, it's a spectrum. So there are different types of activities that can be undertaken, from very informal information exchanges as they are already happening, which don't require any legal changes, to lead agency models, one-stop shops, and even, let's say, more intrusive solutions, such as mechanism to, let's say, internalize a foreign enforcement decision at the domestic level, which of course require legal instruments, which go back to the first point I was making about willingness. So I would say there is a broad discussion on how to move forward, but we really need to consider the different pillars. Together with willingness, I would also put the topic of resources, which maybe we'll get to it later when we talk about obstacles, but I think it's a really important point to make, because willingness is one thing, but because you don't have enough resources, that's a different type of issue. And we have seen how competition authorities worldwide have an issue with budget and resources. So maybe the needs of enforcement and competition policy in digital could be a nice hook to ask governments for more resources, but that's a key point to solve if we want to move forward in this direction. And then I think clarity needs to be made, as I was saying before, on the different needs between enforcement cooperation and legal implementation cooperation and competition policy cooperation, because they're really different layers and might require different solutions.
Anna, you spend also a good time at the OECD in Paris. I know you miss France and the croissant. And so during your time, you also work a bit on this aspect. And I don't know if you want to add something from Carolina.
Well, a good friend of mine from the ACCC actually was involved in that big piece. Can you hear me now?
Yeah, perfect.
Yeah. I was just saying a good friend of mine worked on that piece with the ICN recently, with the OECD on international cooperation, and it's quite the tome. And there are a lot of obstacles to it. But I guess I was just going to cite one thing the ACCC has got with the US Department of Justice, US FTC, the CMA, and the New Zealand Commerce Commission and Competition Bureau of Canada, which is the Multilateral Mutual Assistance and Cooperation Framework. And that's been a really great tool to share intelligence, case theories, investigative techniques, And I think as well that they're looking at things like secondments under that. So it's not specific to digital platforms, but indeed when the media release went out for the ACCC Signing Act back in 2020, digital platforms was really called out as an area where there's so much benefits from that international cooperation. So I think there are some models already out there that could be drawn on, understanding as well that obviously it is different to look at the policy side, and maybe the policy areas need to be part of that discussion as well, because obviously as a regulator we're not making the law, we're hopefully working with the policy makers, but I think they also need to be part of that discussion. And I mean, I think these things do go on through informal channels as well. So we've got a lot out of in the past being allowed into the G7 discussions and being party to those, which has been really beneficial to Australia, but also the OECD, obviously, those discussions on best practice, the side discussions you can have with colleagues in other jurisdictions about the practical issues they're having. The work, obviously, of the International Competition Network as well is really important to drive those debates and discussions. And and also bilateral staff level chats as well are really helpful, and we have a lot of those with everyone here really. So we benefit a lot from that, and I think they're really important tools to keep going with. And I do think the comments as well is a really important tool. And I think as we come, hopefully Australia will get its own laws in some form. And I think talking with the other jurisdictions about, what remedies they're looking at that may or may not comply with their laws or codes or whatever it might be is going to be a really important part of that discussion going forward.
So we can see that from the OECD part, they are working a lot about enforcement, which great job to develop memorandum of understanding or exchange form of cooperation. I know it's something that is close to the earth of Frederick Jenny, which is the head of the OECD competition division, if I'm correct.
The chair of the competition committee. Yeah.
Competition committee, which is different thing from the head of competition division. So now let's move on the second part, which is about what are the proposals that are on the table. Perhaps E1 and Menno, you can speak about a little bit about this topic.
Menno?
Yeah, of course. You want.
Thank you. So, Christoph, you mentioned about our G7 presidency, which we took forward the work to promote cooperation here with the compendium and part of the summit, which Germany took forward. And we look forward to Japan also continuing this work at the G7 level. Just for me, taking a step back, if I think about the way that I think about the benefits of cooperation here in this space are twofold. One is that we can divide and conquer as competition agencies, and the other is achieving strength in numbers. So by dividing and conquering, what I mean is that there are more issues in digital markets than any one individual agency can take forward on their own. So as we're doing with Privacy Sandbox and Google, we can take forward something on behalf of others. Strength in numbers is where there is a particularly strong intervention that some of these firms that will be designated as strategic market status firms are the richest in history with more resources than even some nation states. And it can be difficult for any one individual agency to compel behavior change. So if we work together, we can collectively compel that change. The difficulty is, I think as others have touched on, is the legal enforcement difficulties here. How is it that a jurisdiction can enforce another jurisdiction's ruling, or indeed find against its own firms with respect to something another jurisdiction has decided upon? That really is a level of legal complexity. The other one is the information gathering and sharing restrictions that we all have. That is something that in our legislation, we are proposing to give the CMA more powers to gather information on behalf of other countries and to be able to more readily share information to support joining up of competition more broadly. So that's something that, as Anna mentioned, we have the Mutual Assistance and Cooperation Framework with Australia, Canada, New Zealand and the US, once we have the new powers, and if other countries have similar powers, we can update that, or we could, and we can agree other assistance arrangements with other jurisdictions, including, as is foreseen in the Treaty for leaving the EU, with the European Commission. So I think some of those sort of more formal cooperation arrangements, building on greater information gathering and sharing powers, would be one way forward. But in terms of other proposals, I just have to highlight everything that has been said already of using the OECD, International Commission Network, and the G7 to really push forward these kinds of softer, more informal forms of cooperation for now. Thanks.
Thank you. A very interesting part about the issue of sharing information. I know it's a sensitive one, especially when you speak about confidential information. Menno?
Thank you. I wanted to perhaps give the Digital Markets Act as an example of in a way, an international law already that reflects that need for cooperation and coordination, because inbuilt in the mechanism is a close cooperation with national authorities, competition authorities, and potential future DMA authorities, and with all European authorities as they are represented at European level in different regulatory fields, as well as with courts and with stakeholders, of course. So it's already showing the need within 27 to closely coordinate to achieve that desirable effect, which is that you can act together, as Ewan just mentioned also, to make sure that compliance happens, because these are powerful firms and they are indeed larger than certain nation states. So the 27 member states acting together is very important, but it was clearly recognized in the proposal that you need to cooperate and coordinate. And then to Ewan's second point about exchanging information, that is indeed something very important to already think about now, as other jurisdictions may also move to similar systems. So in the Digital Markets Act external outreach, we're also very much looking at what a future enforcement cooperation may look like, as we have well-established practices in competition law, but we are talking about something different here. So you may see some foundations in different documents, in digital partnerships that the EU has concluded, and in trade and technology councils that we have ongoing with the United States and with India, where there is a very specific attention to online platforms and digital services regulation. And maybe that's a final mention. It's clear, and that's Carolina's point, I think, that both competition and digital requires this coordination and cooperation in enforcement, but also the legislative regulatory approaches need coordination and cooperation. And once implemented, they need a similar enforcement cooperation mechanism. So it's very important to keep both on the radar and going. And also on the EU side, we still have our competition dialogue on digital with the United States and with other partners around the world, of course, through existing mechanisms, with agencies, also through staff exchanges, as Anna mentioned. So I think it's very important to start thinking about the best ways of doing this to make it happen, but also keep in mind that we need digital regulation and competition, both, and that we need perhaps separate solutions for those.
It's also very relevant about this issue of staff. You touched upon a bit, and perhaps this is on the key issue that remains to be addressed, which is right now the discussion we can have together. But what do you see that the issue that should be fixed, or at least should be on the table? I see one issue first is about the question of cooperation between digital regulatory regime. So, about the DMA, we have a lot of provision about data access, and we need coordination about data protection, but also consumer protection. And here we have already some model in place. So in the UK, we have the DSAF, Digital Regulation Cooperation Forum. In Australia, we have the DPREC, Digital Platform Regulation. And under the DMA, we have the high level of expert group, but we have also a model under the DSA. This is the first point that I see from my side. And the second one is the issue about staff. We know that, and I'm well placed to know it. I did my PhD in 2017, and when I want to apply to do it in a law firm, they always say no because we don't have any clients working on digital competition. I did my PhD on big data and competition law, and today is a topic of that is relevant for them, but they don't have enough people with a skill. So the question is that we don't have enough skill, but we need people, and where do we find these people? Perhaps also sharing will be on the table. And the third point that is for me important is also what is the implication of other legal regime. So, for example, privacy may have an impact on competition law regime, and how do you integrate into a digital competition regulation? What would be the effect, for example, of other provision? But I've enough, is enough from my side. Perhaps, Anna, you want to start a bit?
Yeah, just because you mentioned DPReg, I'll give a bit of background. Yeah, obviously, you know, there's digital platforms, services across our economy now, and they're raising challenges and issues across a number of different areas. So we have this Digital Platforms Regulators Forum, or DPReg, and that's comprised of the ACCC, the Australian Communications and Media Authority, or ACMA, the E-Safety Commissioner, the Office of the Australian Information Commissioner. And that means quite regularly to do work to understand areas of potential overlap, and also to assess those difficult trade-offs in regulatory design and other things. So just to give an example, if we went forward in Australia with competition laws, new competition laws for digital platforms, you know, there may be some rules that could potentially have implications on privacy or safety, or maybe the digital platforms argue they do, whether they do or don't. And I think, you know, having these forums to sort of to interrogate those propositions and to test those and to make those trade-offs is really important. Also, Australian governments, like, we're dealing with things like social media reviews at the moment. There's a Privacy Act review, there's misinformation, disinformation work, and lots of parliamentary inquiries going on. So it's really important, I guess, to understand what's happening in this space. Also to be aware of you know, how many requests the various parties are getting from the various different regulators and different parts of government, because I think that really does undermine sometimes your ability to engage effectively. And while digital platforms might have a lot of resources, maybe the consumer advocates don't have those resources, and having them pulled in these very different directions can be quite counterproductive at times. Also, you know, if you develop, you know, on the consumer side, we're looking at things like dispute resolution and new obligations there. If there's other obligations in relation to dispute resolution for misinformation, disinformation, it's really important to understand how those work together for a consumer so that they can work, but also for whoever they apply to, so that you can make sure that it's a sort of coherent package. So there's a lot of reasons, I think, that you need to keep those dialogues going, and that'll, I think that's just going to get more and more important, unfortunately.
About this model about DPREC and the DSCF, I think it's necessary to explain what is a DSCF. It's a little bit like the DPF, but you all know what is it. They're working on the very interesting topics such as Web3 and also the metaverse. But perhaps Menno and Iwan, my question is: do you believe that this kind of framework can be at the supranational level or even at the international level? Because they are national right now, but...
So I would first echo Anna's points that we need to have a broad overview of the problems, and for that we need the competences, so both the expertise in different domains and also the experts. So that is a baseline. But maybe one element, also in response to your question, is we also need to look at society and empower society, because it's simply not even desirable to try to replicate the level of staffing that gatekeepers have within a regulator. What is a really fundamental aspect of regulation is that there is societal oversight. And I think, for instance, the Digital Services Act really injects transparency at all levels of the process of intermediation between different users of a platform. And so you have this provision whereby access to data needs to be given to researchers. And we need a global community of researchers that can look into different issues and inform regulators. We have the auditors that need to have the competence to audit the platforms and serve as a bulwark and a complement to the regulatory authorities. And they also need to make their work public so that we understand the problems better. And competition authorities and other authorities can also benefit from the work they do. And there again, if you have an auditing industry that's specialized in this area, they automatically can have a global impact and be a global resource. So I just wanted to mention that societal aspect, that it's not necessarily about fully replicating what platforms have, but make sure they're accountable by society. And I'm hopeful that we can create, in that sense, at different levels, global cooperation fora, be they in existing supranational bodies or on an informal and ad hoc basis. So you can think of researchers connecting formally and informally to actually engage in this research. And then there's the obvious example that was given where you establish some sort of cooperation framework for regulators, digital regulators, competition regulators, and other frameworks. I think there is also a lot of potential in making sure that there is communication at all levels in it. So using this existing fora and new ones, but very much making sure the society feeds into that and is informed by that.
Do you want to add some things?
Thank you. So, yes, really agree with everything that's being said. The DRCF in the UK, as you mentioned, is the Joint Digital Regulation Cooperation Forum that consists of us and the Competition Markets Authority, and then our sister organisations in Ofcom, Communications Regulator, our Information Commissioner's Office, and the Financial Conduct Authority. We've done a range of work on various different topics. Christoph, you mentioned Web3, but we've looked into algorithms, interactions with online safety, and data privacy. And I think that really highlights that there will always be a need for national regulators to work together. And we indeed will have an obligation in the law as the CMA with respect to our Digital Markets Unit to engage with the other regulators where our actions will interact with their regulatory concurrent regimes. So we're always going to need that at the national level. Taking it to a supranational level, it's very similar to what Menno said, and it's very similar to any kind of other research agenda whereby we can collectively divide and conquer across the world. There are more topics than any one individual agency or cooperation agency at a national level can deal with. So it makes sense for us to try as much as we can to achieve joint work plans. That speaks to the kind of digital cooperation agreements that the EU has, and we have indeed with Singapore and others. So that, I think, yes, it can be done, but of course the inevitable resource implications and practical diplomatic political implications can come into play that are active brakes on some of this. But certainly, yes, dividing and conquering is worthwhile at supranational level, but there will always need to be a national level component to it as well, which will unfortunately suck up probably a lot of this very scarce resources of skills that we have in this space.
Do you see other issues that are meant to be addressed?
Okay, mention one issue. Ewan, you want to?
No, sorry, I couldn't hear your question, Christoph. Could you please repeat it?
Do you see any other issues that are meant to be addressed? I'm asking to all the panelists. But if you want to start, go ahead. You want? Menno?
One thing I was thinking of is the tendency of certain, I would say, more isolated autocratic regimes of copying what is done at a global level for legitimate purposes and use it to channel a different vision for the internet as such. I don't think it's a secret that today even specific platforms are taken down regularly as part of targeted internet shutdowns, and that regimes might have a tendency to try to greenwash that, for lack of a better term, in legislation, which can closely reflect what we do. And I think that is a challenge we will all face as we see global cooperation to acknowledge where legitimate purposes are pursued and exchange with those jurisdictions, and make sure that we design remedies that work everywhere, while calling out bad actors that really abuse the regulation to crack down on their own population. And then hopefully, it's not, of course, our role to act outside our jurisdictions, but to still allow citizens all over the world to be informed about the problems we tackle and how we propose collectively to tackle them. So just that risk inherent in global cooperation.
And maybe just another point that I see as a risk that we have with traditional antitrust enforcement as well, but that if we analyze it under the context of international cooperation, we can actually maybe find solutions about it, is the issue with speed of intervention. Because as much as the enforcement of these new regulations is clearly different from, let's say, a traditional abuse of dominance case that in many jurisdictions can take maybe from 3 to 10 years, it is still possible. Maybe you have a better insight, but I think it's still highly likely that many of these platforms will not comply. So what happens next? If the process of the investigation in that case takes a decade, I think we can see how companies might implement different strategies to kind of exploit this speed issue and kind of work around the law and the enforcement process. So maybe international cooperation can also help from this perspective, which would really be key for companies to see these authorities are really on it. They really react fast. And if we don't comply, we will see consequences fast, rather than if we don't comply, maybe in 10 years, something will happen. So cost benefit, maybe we can try to get away with it. And I think that should be a priority to be taken into account together with the international cooperation aspect.
This is why in Germany they decide to go directly to the court if there is an issue to shorten at least the judicial review. Before I open the floor to the Q&A, maybe Anne and Ewan, you want to touch upon this topic? No? Ewan? No? Okay, all is clear. So the floor is yours. Do you have any question about this aspect? Yeah, one.
Hello, my name is Vlad Vita, and I'm from the Association of Commercial Televisions. I have two questions. First one is more addressed to the Commission. You talked about coordination and enforcement at the national level of the DMA. And I was wondering, how is the Commission willing to incentivize the national authorities to take an active role in investigating matters, given that they know their role would be limited in terms of actually implementing the remedies which the Commission will adopt? That's my first. And the second one is more broader. It's on international cooperation and the Activision Blizzard Microsoft merger, which is a good example in terms of divergence, in terms of assessing competition concerns, and what are the aims. In the US, the merger is trying to be blocked, whereas the EU is still assessing, whereas Brazil and Saudi Arabia have already approved the merger. Wouldn't this merger be a good opportunity to look at a substantial need to share information across borders? Thank you.
So, Menno, perhaps you want to answer the question. As a second, I have an idea, but I don't know if you want to speak about the Activision merger, which apparently in Europe and the UK are, from what I understand, sending statement of objections to perhaps block the merger. And to answer the question why small jurisdictions such as Saudi Arabia or I don't remember Brazil, the other jurisdiction already clears a merger because perhaps are small jurisdictions and they don't have they have national I would say characteristics that is not reflected in big jurisdictions such as in the UK or in Europe.
Thank you for the excellent question. I think it went towards the issue of budgetary constraints, resource constraints, of course, and the need for enforcement priorities. But I would fundamentally hope that incentivization in this case is not necessary, but that the fact that digital power concentration is the top priority to tackle, and that national authorities have all the incentive they need to assist the Commission to make sure that it is aware of all of the issues out there and that it can tackle those that are that need to be tackled as a matter of priority. And in this context, it's reassuring to see that maybe different from the past, that on the Digital Markets Act, member states, and of course also informed by independent authorities, really came together and were unanimous in their conviction that this problem needs tackling through, first of all, this harmonized regulation, which includes that cooperation mechanism or the built-in cooperation with authorities. So I have very good hopes for that.
We are rushing a little bit on time because it's not a bit late. But I can take just one or two more questions, then we'll have to close this conversation. No more questions from your side. So as a final word, if you want to add some things, feel free.
Maybe I will start. I think one important conclusive point to make, which already Amelia Fletcher made last year, but I think it's important to stress it again, is that when it comes to these ex-ante regulations, we don't necessarily need like a perfect regulatory alignment in terms of design, which would be impossible to achieve at the global level, considering all the different political, cultural, and domestic needs of different countries. But even a slight regulatory divergence can be overcompensated by an enhanced coordination at the implementation level. So I think that we should not focus too much on the divergences from the regulatory perspective, provided that we know that the objectives are very much shared. But then this also means that there should be an increased effort in terms of coordination at the implementation level.
Can I echo
Of course.
those points? That's very crucial that you mentioned that. And I would also say I'm slightly more hopeful than 10-year perspectives for enforcement solution, because I think these regulations have looked at the problem and decided to design a system whereby you can designate firms and then have practices apply. And the discussion can feature around the designation and the numbers. And then you can have discussions around how specific technicalities of a compliance measure are designed, but they need to happen in all cases. And in that context, another point I wanted to echo is that I'm really hopeful that with the coordination and cooperation globally, we can prevent that private gatekeepers are our privacy regulator, because this is the argument you often hear and what the discussions may feature around, that it will affect security and privacy. But there are ways to design implementation measures that provide better privacy and security. And we need collectively to be the privacy and security regulator and pull in those resources, but make sure that we achieve a better situation than today.
Iwan, I see that you have the end left.
Thank you. I just wanted to leave my last point by echoing what others have said there, that again, there is more that unites us than divides us. And when, in particular in the UK and Australia and other jurisdictions, we're in the process of introducing new legislation, that is going to be subject to considerable debate that will be fueled by potential gatekeeper or strategic market status companies who are the best resource companies in history who are extremely good lobbyists. So they will, I think, exploit any divisions that we have between us, and we need to be guarded against that and supportive of each other's proposals to try and help make the case to get it through our respective parliaments.
Thank you. And Anna?
As a jurisdiction currently in that process, so I can't not echo those comments. So I think it is really important to encourage the adoption of regimes in the first place. And then, like anything, things will probably evolve over time. And as long as we're having those discussions and cooperating on these, I think there's reason to be optimistic rather than pessimistic about the direction in which everything's heading. So, but thank you very much for being invited today, and very interesting discussion.
Thank you for your time. I know it's late in Australia, and thank you everyone for being there, the panelists, but also you that your presence is not very easy to speak with this. But thank you so much, and enjoy the sun this afternoon. Bye bye.